Good day, everyone. Welcome again to another lecture on civil procedure. The topic for today is venue of actions. Okay. Many confuse jurisdiction and venue. Okay. However, they are two different or distinct concepts that we shall discuss. Okay. Now, in determining the venue of actions, you have to first classify or distinguish between real actions and personal actions. What is a real action? A real action are actions affecting title to or possession of real property or interest therein. The venue of real actions is the court, which has jurisdiction over the area where the real property is situated. Okay. On the other hand, forcible entry and detainer actions are also real actions, but they shall be commenced and tried in the municipal trial court of the municipality or city where the real property is situated. Okay, so the rule of thumb with respect to actions affecting title to or possession of real property, the crucial point that you have to consider is the location of the property. Because it is the location of the property where the venue of the action should be instituted. Okay. How about personal actions? All other actions may be commenced and tried where the plaintiff or any of the principal plaintiff resides, or where the defendant or any of the principal defendant resides. In case of a non-resident defendant, where he may be found at the election of the plaintiff. So with respect to personal actions, the crucial point to consider is the residence of either the plaintiff or the defendant at the election of the plaintiff. Okay. How about with respect to non-residents? If any of the defendants does not reside and is not found in the Philippines, and the action affects the personal status of the plaintiff or any property of said defendant located in the Philippines, the action may be commenced and tried in the court of the place where the plaintiff resides or where the property is situated. Okay, so with respect to actions, quasi in rem, when we speak of actions quasi in rem, okay, it is an action involving the personal status of the plaintiff or any case involving the property, a property located in the Philippines. Then in case the defendant is not a resident, then the plaintiff may choose to file the case in the place where he resides or in the place where the property or any portion thereof is situated. Okay, so that is the rule regarding venue. It must be emphasized that jurisdiction is different from venue. Jurisdiction is, how shall we call it? It is generic. Generic in the sense that when the law confers jurisdiction upon a certain court, it confers the general power to try, hear, and decide those cases. On the other hand, let us say, let us give an example. For example, a contract for a case for collection of sum of money. Okay, the amount of which exceeds 2 million pesos. So the law says that jurisdiction over the said action belongs to the regional trial court. Okay, but there are so many regional trial courts in the entire country. So where do you file the case? So the general rule, you consult the rule on venue of actions. Okay, so since a collection of sum of money is a personal action, because it does not involve title to or possession of real property. Okay, the next thing that you must consider is, where is the residence of the plaintiff? Where is the residence of the defendant? So at the election of the plaintiff, okay, his residence will be the place where he will file the action. So if, for example, the plaintiff is a resident of Cabanatuan City, then he can file the action for collection of sum of money in the RTC of Cabanatuan City. But all the RTCs in the entire Philippines, okay, have jurisdiction over the said action, considering that the amount of the amount being collected exceeds 2 million pesos. However, can the parties, for example, stipulate that the venue of the action will be in Makati City or will be in the city of Manila? The answer is yes, if there is an exclusive stipulation on venue. Under Section 4, the foregoing rules are not applicable. The rule on venue, okay, in the following cases, if there is specific rule or law providing otherwise, and when the parties have validly agreed in writing before the filing of the action on the exclusive venue thereof. Okay, so there are two exceptions to the general rules on venue. Okay, first, if there is a specific law, okay, that is not consistent with sections 1 to 3. Okay. And second, when there is an exclusive stipulation on venue agreed upon by the parties before the filing of the action. In such cases, the rules on venue under sections 1 to 3 will not apply, but the stipulation of the parties on venue will apply. Why? Because the contract is the law between the parties. And you must remember always that venue is for the convenience of the parties. So it can be waived, okay, and you can be estopped from raising the defense of improper venue. Okay, because it is something which can be stipulated or which can be waived. Unlike jurisdiction. Jurisdiction over the subject matter, as I have repeatedly stated, cannot be waived. Okay? It can be raised at any stage of the proceedings, even on appeal. It cannot be stipulated upon by the parties. Why? Because jurisdiction is conferred by law. On the other hand, venue is a procedural matter. Being a procedural matter, it is designed for the convenience of the parties. That is the reason why in formulating the general rules on venue, okay, the Supreme Court took into consideration the location of the property in real actions, because the court which is situated, okay, in the place where the property is located should be the place to file the action. Okay. And with respect to personal actions, the court took into consideration the residences of the plaintiff and the defendant, because it is primarily designed to make it convenient to the parties. You can just imagine if, for example, the residence of the plaintiff is in, let us say, Cabanatuan City and San Jose City, and then you will the venue will be, for example, in Cagayan de Oro City. So it would be very burdensome and inconvenient for the parties to file the action in that place. Okay, which will require the parties to ride a plane in order to reach the court where the action is filed. Okay? So okay, now it is time to distinguish between venue and jurisdiction. The distinction between venue and jurisdiction. Venue is a matter of procedural law, as I was saying, while jurisdiction is conferred by substantive law. So it is conferred by Congress through a law, okay, determining the courts which have jurisdiction over certain cases. On the other hand, venue is a matter of procedural law, and it can be waived or stipulated by the parties. On the other hand, jurisdiction is conferred by law and thus cannot be waived or be the subject of an agreement. Okay, that is the reason why I am always bothered whenever during the pre-trial, the parties would uh, offer for stipulation that this court has jurisdiction over the case. As I have repeatedly stated during the hearings conducted in my sala, jurisdiction can never be the subject of stipulation because it is the law that confers jurisdiction. And even if the parties stipulate that the court has jurisdiction over a certain case, it does not, the parties do not have the power to confer jurisdiction over cases. It is always Congress through a law that gives the court power or authority to hear, try, and decide cases. Okay. In the case of Mendiola versus CA, the Supreme Court pronounced venue relates only to the place of trial or the geographical location in which an action or proceeding should be brought and does not equate to the jurisdiction of the court. It accords convenience to the parties as it relates to the place of trial and does not restrict their access to the courts. In contrast, jurisdiction refers to the power to hear and determine a cause is conferred by law and not by the parties. Okay, we now go to the first case, Rudolph Litz Holdings versus RD of Parañaque. In this case, the petitioner Rudolph amended its articles of incorporation to change its name. The petition was filed before the RTC of Parañaque, seeking the amendment of the name of the owner in the transfer certificates of title over the real properties located in Pasay City. So the lower court or the trial court dismissed the petition motu proprio or by itself without waiting for any motion on the ground of improper venue because it is the position of the trial court that since the properties are located in Pasay City, they should have commenced the action not in Parañaque but in Pasay City, which is the location of the property. However, the Supreme Court said the trial court erred when it dismissed the petition motu proprio. It should have waited for a motion to dismiss or a responsive pleading raising the objection of improper venue before dismissing the petition. Okay, you must remember that the moral of the story in the case of Rudolph versus RD of Parañaque is that the court cannot by itself, motu proprio, without any motion, dismiss a case for improper venue. Okay. The venue of an action as fixed by statute may be changed by the consent of the parties, and an objection on improper venue may be waived by the failure of the defendant to raise it at the proper time. It is meant to provide convenience to the parties rather than restrict their access to the court as it relates to the place of trial. So meaning, if there is no objection on the ground of improper venue, the case may be tried and heard in the court where the case is filed, even if under the general rules on venue, it is not supposed to be the place where the case should be filed. Why? Because venue is designed for the convenience of the parties. And if there is no objection on the part of the other party, it means that he is also amenable to having the case tried in that court, even if it is not the place which is provided under the rules where it should be filed. Okay, because it is designed for convenience of the parties, the non-objection means that he is waiving his right the to invoke dismissal on the ground of improper venue. So meaning he is agreeing that the case should be tried in the court, even though under the rules it is not the proper venue. Davao Light versus Court of Appeals. In this is a case for damages uh, against Tesorero before the RTC of Cebu City. Okay, Tesorero moved to dismiss on the ground of improper venue. Tesorero claimed that um, its principal place of business is in, the petitioner claimed that its principal place of business is in Cebu City, while the contract executed with Napocor state that its principal office is in Davao City. So the motion of Tesorero was that the principal place of business of Davao Light is in Davao City and not in Cebu City. Okay, the Supreme Court said the RTC of Cebu as the proper venue was upheld. Okay, petitioner's principal place of office is in Cebu City. An action for damages being a personal action, the residence, okay, which is the principal place of business of the in case of a corporation, is the place of the venue of the action. So the principal issue involves a question of venue. It is to be distinguished from jurisdiction. Venue and jurisdiction are entirely distinct matters. Jurisdiction is not conferred by consent or waiver upon a court, but the venue of an action as fixed by statute may be changed by the consent of the parties, and an objection that the plaintiff brought his suit in the wrong county may be waived by the failure of the defendant to make a timely objection. In either case, the court may render a valid judgment. Rules as to jurisdiction can never be left to the consent or agreement of the parties whether or not prohibition exists against their alteration. An action for damages being a personal action, venue is determined pursuant to Rule 4, Section 2 of the Rules. Okay. We now go to the case of Ray Joel versus Pineda. Ray Joel alleged in its complaint that it extended a loan to Pineda, which was secured by a chattel mortgage over a vehicle. Okay, in the promissory note, there was a stipulation stating that any action to enforce payment of any sums due shall exclusively be brought in the proper court within the National Capital Region or in any place where Radio Wealth has a branch office at its sole option. Okay, so when Pineda incurred default, petitioner filed a suit for collection, an application for a writ of replevin before the Regional Trial Court of San Mateo, Rizal. Okay, alleging that it has a branch in San Mateo, Rizal. Now, the RTC recalled the writ of replevin and ordered the dismissal of the complaint on the ground of lack of jurisdiction. It pointed out that petitioner's principal place of business is Mandaluyong. Respondent's residence is in Porac. Therefore, it has no jurisdiction over any of the party litigants. In this case, the venue stipulation found in the promissory note is a restrictive stipulation, considering that it limits the venue of actions to the courts of the National Capital Region or where in a place where Radio Wealth has a branch. In light of the petitioner's standing allegation that it has a branch in San Mateo, Rizal, it appears that the venue has been properly laid, unless and until the defendant objects to the venue in a motion to dismiss. The venue cannot be truly said to have been improperly laid, as for all practical intents and purposes, the venue, though technically wrong, may be acceptable to the parties for those for whose convenience the rule on venue had been devised. Okay? Venue in real or personal actions. Previously, I have already explained to you the distinction between a real action and a personal action. To reiterate, real actions are those affecting title to or possession of real property or any interest therein. It is commenced as a general rule. It is commenced in the court of the place where the real property is situated. An example of a real action are actions for partition, foreclosure of real estate mortgage, forcible entry, and unlawful detainer. Okay, on the other hand, personal actions are all the other cases which are not real actions. The important thing again to consider with respect to personal actions is the residence of either the plaintiff or the defendant at the choice of the plaintiff. So the residence of a corporation, on the other hand, is the province or city where its principal place of business is located. Okay, we now go to the case of Kabutihan versus Land Center Construction. Okay, Kabutihan filed an action for specific performance with damages before the RTC of Pasig City. So what is specific performance with damages? It is a personal action. Okay, they pray that Land Center execute the required deeds of transfer and conveyance of a portion of property situated in Parañaque. So you must remember that in determining what kind of action is involved, you don't only look at the title of the action. Okay, but you also look more importantly on the allegations as well as the prayer of the petition. In this case, the principal relief sought is the execution of deeds and transfer and conveyance of a portion of real property situated in Parañaque. Okay, so the RTC of Pasig dismissed the complaint on the ground of improper venue. So in this case, actions affecting title to or possession of real property, real action shall be commenced in the court which has territorial jurisdiction over the area where the property is situated. All other actions, personal action shall be commenced in the courts where the plaintiff or any of the principal plaintiff resides or where the defendant resides. In this case, petitioner sought payment of her services in accordance with the undertaking the parties signed. Breach of contract gives rise to a cause of action for specific performance or rescission. Okay. Breach of contract, hence the assessed value of the real estate should not be considered. Okay, we now go to the case of Paderanga versus Guisan. In this case, Guisan filed an action for damages before the RTC of Zamboanga del Norte based in Bacolod City. Petitioner is a resident. Paderanga is a resident of Ozamis. Moved for its dismissal, contending that the action was a real action which should have been filed with the RTC of Misamis Occidental where the property in question was situated. Okay, remember the case is one for damages. So basing on the title, it is actually a personal action. But the petitioner was contending that it is a real action. Paderanga argues that inasmuch as the main relief sought is to recover possession of the portion surrendered to him, as well as to fix the period of the lease, the polog could not be the proper venue. It being a real action, venue is laid in the court having jurisdiction over the territory in which the property lies. On the other hand, Elumba counters that the action is chiefly for damages arising from breach of the lease contract. Hence, the issue of recovery of possession is merely incidental. Okay, an action in personam is an action against a person on the basis of his personal liability, while an action in rem is an action against the thing itself instead of against the person. So it is imperative to find out what kind of action is involved in this case. While it may be that the complaint does not explicitly pray for recovery of possession, it is the necessary consequence thereof. This case, therefore, does not operate to efface the prime objective of the nature of the case, which is to recover the half portion repossessed by the lessor, where the ultimate purpose of an action involves title to or seeks recovery of possession, partition or condemnation of or foreclosure of mortgage, such an action must be deemed a real action. So even though the action was denominated as one for damages, the main prayer or relief sought is one for recovery of possession. And therefore, it must be classified as a real action. And therefore, the proper venue should be the place where the property is located. Go versus UCPB. Go was granted by UCPB a credit line accommodation, okay, which was secured by a real estate mortgage on lots located in Mandaluyong. Now, upon default, okay, the bank extrajudicially foreclosed the two lots. Now, to protect his interests, Go filed a complaint with the RTC for cancellation of the real estate mortgage against UCPB. The bank filed a motion to dismiss the complaint. Okay, now the issue is whether petitioner's complaint for cancellation of the real estate mortgage was a personal or a real action for the purpose of determining the venue. Okay, the Supreme Court said the cancellation of real estate mortgage was a real action, considering that a real estate mortgage is a real right and a real property by itself. An action for cancellation of real estate mortgage is necessarily an action affecting title to the property. Therefore, the action should be commenced and tried in the place where the property lies. Okay, so it is very explicit. An action for cancellation of real estate mortgage is a real action. Therefore, for the purpose of venue, you determine where the property is situated. A real action is one affecting title to or possession of real property. These include partition, condemnation, foreclosure. The venue of a real action is the same for RTCs and MTCs. The court which has territorial jurisdiction over the area where the real property lies. Personal action is one brought for the recovery of personal property, for the enforcement of some contract, or recovery of damages for its breach, or for the recovery of damages for the commission of an injury to the person or property. Venue for personal actions is the court of the place where the plaintiff or where the defendant resides at the election of the plaintiff. An action for nullification of mortgage documents and foreclosure of mortgage property is a real action that affects title to the property. Thus, venue is the court having jurisdiction over the property in which the property lies. Maham versus Madrigal. In this case, Madrigal filed the complaint for quieting of title against Maham in RTC of Tagaytay. Now, Maham moved to dismiss the complaint on the ground of improper venue because per his title, the property is located in Talisay, Batangas, which is under the territorial jurisdiction of RTC Tanawan. Now, the issue is whether the RTC was correct when it dismissed the case on the ground of improper venue. Ah, what I mean is whether the RTC acted with grave abuse of discretion in ruling that the venue was properly laid and in reconsidering its earlier order to dismiss. Okay. The Supreme Court again reiterated that venue is the place where the case is to be heard or tried. An action for quieting of title being a real action should be tried in the court having jurisdiction over the area where the real property is situated. A reading of the title shows that the subject property is situated in Tagaytay City. While petitioners claim that the property is located in Batangas, the allegations of the complaint remain controlling insofar as jurisdiction and venue are concerned. So for the purpose of venue, you also consult the complaint in determining the proper venue. Pamaran versus Bank of Commerce. So in this case, Rosa filed a complaint for damages against the bank when it foreclosed her lots in Muntinlupa on which her house stood. Okay, the claim of Rosa is that her house was not included in the loan amount. However, the bank foreclosed not only the lots but also her house. So, Bancom filed petitions for issuance of writs of possession which were granted. Now, Bancom argued that the complaint should have been filed before the RTC of Muntinlupa, where the real property is located. It maintains that while the complaint was denominated as one for damages, uh, the action is in fact a real action because it is based on Rosa's claim of ownership over the house built on the subject lots. Rosa, on the other hand, contended that it is a personal action because she is not asking to be the owner or possessor of the house but is merely praying that Bangkok be ordered to pay her damages. So you must remember that you always consider in determining what kind of action is involved in the suit for the purpose of determining venue. You always consider the principal relief sought. So in this case, this is a case for damages. So a case for damages from its name implies that it is a personal action. But the box said that what is involved here is a real property, the house. Okay. On the other hand, Rosa was claiming that he's not claiming recovery of possession or ownership of the house. He's merely asking for damages because the bank foreclosed a property which is not included in the loan. Okay. This case is one for recovery of damages relating to the injury committed by Bangkok for violating Rosa's right to due process and right to enjoy her house. Rosa averred that she does not seek recovery of its possession or title. Her interest is merely incidental to the primary purpose for which the action is filed, and that is to claim for damages. Clearly, this action involves Rosa's interest in the value of the house. She's not interested in the house itself. Indeed, the primary objective of the complaint is to recover damages, not to regain ownership or possession of the subject property. Hence, this is a personal action which is properly filed in the RTC of Olongapo, where Rosa is a resident. We now go to the venue of actions quasi in rem. What is a quasi in rem proceeding? A proceeding quasi in rem deals with the status, ownership, or liability of a particular property, but which are intended to operate only between the parties to the proceedings and not to cut off the rights or interests of all possible claimants. A quasi in rem judgment binds only the parties who are joined in the action. Okay. So the venue is where the plaintiff resides or where the property or any portion thereof is situated. Summons on the defendant may be served through extraterritorial service. An action to quiet title may be in rem or quasi in rem. Therefore, the venue is the place where the property is situated. San Pedro versus Ong. In this case, San Pedro bought from Narciso parcels of land and hired the services of De La Peña to transfer the title to his name. However, the subject properties were still registered in the names of Narciso and were mortgaged to Ong. Okay, in order to free the properties from the said encumbrance, San Pedro filed a petition to nullify the mortgage with damages against Narciso and De La Peña. So all the defendants filed an answer except De La Peña, who was declared in default. Now the RTC rendered a decision declaring null and void the mortgages constituted over the subject properties in Ong's favor. Ong appealed, assigning as error the lack of jurisdiction of the trial court over the person of De La Peña. Okay. To provide a perspective, it is crucial to determine whether the action is in rem or quasi in rem. In this case, which was filed by San Pedro, it is anchored on his claim that he is the real owner of the properties. Thus, no one else has the right to mortgage them. And the mortgage constituted on them may be considered as a cloud on his title. San Pedro alleged that the mortgages in favor of Ong may appear valid and effective, but are actually invalid or voidable, for it having been made without his authority. In asking the cancellation of the mortgages, San Pedro was asking the trial court to remove a cloud on his title. It is thus clear that it is an action to quiet title. Suits to quiet title are proceedings quasi in rem. In an action quasi in rem, an individual is named as defendant. However, unlike suits in rem, a quasi in rem judgment is conclusive only between the parties. Actions in rem deal with the status, ownership, or liability of a particular property, but which are intended to operate on these questions only between the particular parties, and not to ascertain or cut off the rights or interests of all the other possible claims. In actions in rem or quasi in rem, jurisdiction over the person of the defendant is not a prerequisite to confer jurisdiction on the court, provided that the court acquires jurisdiction over the rest. Summons must be served to the defendant in order to satisfy due process requirements. Given that this case is an action to quiet title, which was quasi in rem, the RTC was not required to acquire jurisdiction over the person of De La Peña, it being sufficient to acquire jurisdiction over the rest. The service of summons to the defendants De La Peña did not affect the jurisdiction of the RTC to hear and decide the case, and did not invalidate the proceedings on the basis of jurisdiction. Okay. What is the venue for other cases? So far we have discussed the venue for real actions, the venue for personal actions, the venue in case of a non-resident defendant. How about with respect to other cases? With respect to small claims cases, the venue lies at the place of the residence of the plaintiff or of the defendant at the option of the plaintiff. In case the plaintiff is in the business of lending, banking, venue is at the place of the city or municipality where the defendant resides and in which the plaintiff has a branch office. Okay. On the other hand, the venue of a petition for insolvency is the RTC designated as commercial court where the insolvent debtor resides. When the insolvent corporation abandoned the principal office, the corporation is considered as a resident of the city where its actual principal office is currently found. With respect to petitions for extrajudicial foreclosure, it is the venue is at the in the place where the property is situated. So a while ago, we have already discussed that as a general rule, venue is determined by sections 1 to 3. However, if there are stipulations, restrictive stipulations on venue, then that restrictive stipulation will govern. And if there is a law providing otherwise, such as in these cases, for small claims, for insolvency, for extrajudicial foreclosure of real estate mortgages, this will govern and not the general rules on venue. Okay, La Torre versus La Torre. In this case, La Torre filed before the RTC of Muntinlupa a complaint for declaration of nullity of a deed of absolute sale against her own son. Now, the respondent filed a motion to dismiss on the sole ground that the venue of the case was improperly laid. Okay, in truth, the case was a real action affecting Title II and interest over the subject property. Since the property is located in Makati, the petitioner should have filed the case before the RTC of Makati and not Muntinlupa. In this jurisdiction, we adhere to the principle that the nature of an action is determined by the allegations in the complaint itself rather than by its title or heading. What determines the venue is the primary objective for the filing of the case. Petitioner's complaint is a real action involving the recovery of the property on the basis of her co-ownership thereof. So in this case, the venue should have been in the RTC of Muntinlupa, where in the RTC of Makati, where the property is situated. Okay. BPI family versus UWICO. The City of Manila filed a complaint against UWICO for expropriation of parcels of land located in Tondo. Okay. Now, two of the parcels of land were mortgaged to BPI. Now, BPI decided to extrajudicially foreclose the mortgage. BPI sued after holding the public auction. The sheriff awarded the lots to BPI as the highest bidder. However, since there is a deficiency, BPI sued the respondents to recover the deficiency in the Makati RTC. Remember, the property was situated in Tondo, Manila, but the suit for recovery of deficiency judgment was filed in the RTC of Makati. Now, how do you classify an action to recover deficiency judgment? Okay, is it an action, a real action, or is it a personal action? Okay, respondent contended that the action for the recovery of deficiency being a supplementary action of the extrajudicial foreclosure was a real action should have been brought in the Manila RTC because Manila was the place where the property was situated. Based on the distinctions between real and personal actions, an action to recover the deficiency after the extrajudicial foreclosure is a personal action, for it does not affect title to or possession of real property or interest therein, because it is solely for collection of the deficiency judgment. Okay, its prime objective is to collect, okay, the deficiency judgment, okay, and not recovery of title to or possession of real property. We now go to stipulations on venue. As I have said, the general rules on venue will not apply if there is a stipulation on venue, a restrictive stipulation on venue to the contrary, which was agreed upon by the parties before the filing of the case. Such stipulation is valid even if none of the parties reside therein, or even if the stipulated venue is not the location of the property subject of the action. Stipulations on venue may be either restrictive or permissive. In restrictive stipulations, the suit may be filed only in the place agreed upon. So it's exclusive, restrictive. Okay. Stipulation is deemed restrictive through the use of the words exclusively, waiving any other venue, shall only, to the exclusion of all the other words. On the other hand, in permissive stipulations on venue, the parties may file the suit not only in the place agreed upon, but also in the places fixed by law. So in other words, if you have a permissive stipulation, that is only an additional venue. It does not mean that you cannot file the suit in the courts which are fixed by law as the proper places of venue. Okay, in the absence of restrictive words, the stipulation on venue is merely regarded as an additional forum and not limiting the venue to what was agreed upon. Okay, the effect of a restrictive stipulation is that the action cannot be filed in any other venue, save what was agreed upon. The effect of permissive stipulation is that the action may be filed in the agreed venue as well as the venues fixed by law. Okay. Odilao versus Union Bank. In this case, Odilao filed before the RTC of Davao City a complaint, praying that the subject loan and mortgage agreements executed in favor of Union Bank are contracts of adhesion, therefore must be reformed to reflect their true intention. Okay. Union Bank argued that the case should be dismissed on the ground that the loan document stated that the venue of the action should be before the courts of Pasig City. Remember, the case was filed in the RTC of Davao City. Okay. The stipulation on venue reads as follows. The venue of all suits arising from this mortgage shall be Pasig City or in the place where any of the mortgage properties are located at the absolute option of the mortgagee, the parties here to waiving any other venue. Okay. Clearly, the venue stipulation is not permissive but restrictive in nature. So the petitioner's complaint, which was filed with the RTC of Davao, where the mortgage property is located, should not have been dismissed, as the same complied with the venue stipulation stated in the real estate mortgage. So rules on venue are intended to provide convenience to the parties rather than restrict their access to the courts. It simply arranges for the convenient and effective transaction of business in the courts. The preferred venue must be stipulated in writing before a case is filed. Planters Development Bank versus Ramos. So in this case, Ramos applied for several credit lines with planters for the construction, to finance his construction. Spouses Ramos were not able to pay, and therefore PDB filed a petition to extrajudicially foreclose the real estate mortgage before the RTC of San Jose. Now Ramos filed a complaint for annulment of real estate mortgage against planters also before the RTC of San Jose. Planters moved to dismiss, alleging that the venue of action was improperly laid, considering that the real estate mortgage contained a stipulation that any suit arising therefrom shall be filed in Makati City only. Okay. So the mere stipulation the Supreme Court held on venue is not enough to preclude parties from bringing a case in other venues. The parties must be able to show that such stipulation is exclusive. In the absence of qualifying or restrictive words, the stipulation should be deemed as merely an agreement on additional form. In the the stipulation reads as follows: in the event of suit arising from this mortgage, the parties agree to bring the cause of action exclusively in the proper court of Makati. The mortgagor waiving for this purpose any other venue. So the words exclusively and waiving for this purpose any other venue are restrictive. The clear intention to restrict the venue of any action to a particular place to the exclusion of all other jurisdictions. Parties may, by stipulation, Parties may, by stipulation, waive the legal venue, and such waiver is valid and effective, being a mere personal privilege, which is not contrary to public policy or prejudicial to third persons. In this case, Ramos had validly waived their right to choose the venue of actions arising from mortgages when they agreed to limit the same to Makati City only and nowhere else. True enough, the stipulation on venue was couched in a language showing the intention to restrict the filing of the action to the designated place only. It is crystal clear that the intention was not just to make the place an additional forum, but the only venue where any suit or action pertaining to the mortgage may be filed. While they may have qualms over some of the terms stated, the same do not pertain to the lack of any of the essential elements of contract that would render it void altogether. Such being the case, the stipulation of venue stands and should have been upheld. Now go to the case of Union Bank versus Maunlad Homes. Union Bank and Maunlad entered into a contract to sell involving the Maunlad shopping mall. Now, when Maunlad failed to pay the amortizations, Union Bank instituted an ejectment suit before the METC of Makati City. Now, the METC dismissed the ejectment and the judgment was affirmed by the RTC. Maunlad Homes questioned the venue of Union Bank's unlawful detainer action, which was filed in Makati City, while the contested property is located in Malolos, Bulacan. Okay. Now, Section 4 provides that the rule shall not apply where the parties have validly agreed in writing before the filing of the action as to the exclusive venue thereof. The court upheld the validity of a stipulation providing for a venue of ejectment actions other than that stated in the rules of court. Since unlawful detainer is connected with the contract, Union Bank rightfully filed the complaint with the METC of Makati City. Okay? We now go to the case of Briones versus Court of Appeals. There was a complaint filed by Briones for nullity of the mortgage contract, claiming that his signature was forged. Now, Cash Asia moved to dismiss on the ground of improper venue. On the ground that there was stipulation in the contract that the exclusive venue for the case should be in the proper court of Makati City. Okay, Briones opposed on the ground that should not be covered by the venue stipulation because he was never a party therein, because his claim was that his signature was forged, and therefore why should he be bound by a contract which he did not sign? Okay. General rule is that venue of real actions is the court, which has jurisdiction over the area where the real property involved is situated. The parties to a written agreement may introduce another venue where actions arising therefrom may be fined. Jurisprudence instructs that the stipulation must be exclusive. So in the absence of restrictive words such as exclusively waiving for this purpose any other venue to the exclusion of other courts, the stipulation should be deemed merely as an agreement of an additional court. A complaint directly assailing, however, a complaint directly assailing the validity of the written instrument should not be bound by the exclusive venue stipulation, uh, and should be filed in accordance with the general rules on venue. So in this case, Briones' complaint directly challenges the validity of the contracts claiming forgery. Given this circumstance, he cannot be expected to comply with the venue stipulation, as it would mean an implicit recognition of their validity. Hence, pursuant to the general rules on venue, Briones properly filed his complaint before the court in the city of Manila where the property is located. So in other words, if you're assailing or challenging the validity of the contract where the restrictive stipulation on venue can be found, okay, you are not bound. Why? Because you are directly challenging the said contract. Why should he be bound by a provision in a contract which he is challenging on the ground that he did not sign the same? So with respect to those in that kind of situation, you follow the general rules on venue. Langkaan Realty versus UCPB. In this case, Langkaan executed a real estate mortgage over its property in favor of UCPB as security for a loan. Now, Guimaras defaulted to pay the loan. As a result, the property was extrajudicially foreclosed and sold with the bank as the highest bidder. Now, the petitioner filed a complaint for annulment of the extrajudicial foreclosure and sale. Now, the sole issue is whether or not the extrajudicial foreclosure sale was valid on account of the non-compliance with the provisions of Act 3135 on venue. Okay. The court ruled that failure of the petitioner to oppose or object to the holding of the sale of the wrong venue is deemed a waiver of that right and could not belatedly raise its objection. It is a basic legal principle that venue is waivable. The extrajudicial foreclosure sale cannot be held outside of the province where the property is situated. The extrajudicial foreclosure sale could be held at Trece Martires, the capital of the province, which has territorial jurisdiction over the foreclosed property. However, since the stipulation of the parties lack qualifying or restrictive words to indicate the exclusivity of the agreed forum, the stipulated place is considered only as an additional, not a limiting venue. Okay, therefore, the stipulated venue and that provided under Act 3135 can be applied alternatively. So the venue of the sale should be at the municipal building of Dasmariñas since the foreclosed property is located in Dasmariñas. Well known is the basic legal principle that venue is waivable. Failure of any party to object to the impropriety of venue is deemed a waiver. We find that such waiver was exercised by the petitioner. Failure of the latter to object to the venue of the sale constitutes a waiver. Uniwide Holdings versus Cruz. So in this case, Uniwide entered into a franchise agreement with Cruz. It appears that Cruz had purchased goods from Uniwide affiliated companies. Now, FPC executed deeds of assignment in favor of UHI, assigning all their rights and interests over Cruz accounts payable to them. Now, Uniwide filed a complaint for collection sum of money. before the RTC of Parañaque against Cruz. Cruz moved to dismiss on the ground of improper venue, contending that the courts of Quezon City is the exclusive venue of actions based on their agreement. Okay, now the issue is whether a case based on several causes of action is dismissible on the ground of improper venue where only one of the causes of action arises from a contract with exclusive venue stipulation. So we now here have a case of joinder of causes of action. Now, there are several causes of action joined in one case, okay? And however, only one of the causes of action have a venue stipulation. Okay. Where there is a joinder of causes of action between the same parties, one of which does not arise out of the contract, where the exclusive venue was stipulated upon, the complaint may be brought before other venues, provided that such other cause of action falls within the jurisdiction of the court and the venue lies there. The deeds bear no exclusive venue stipulation with respect to the causes of action thereunder. Hence, the general rule on venue applies. Exclusive venue stipulation embodied in a contract restricts or confines parties when the suit relates to breach of the said contract. But where the exclusivity clause does not make it necessarily encompassing, such that even those not related to the enforcement of the contract should be subject to the exclusive venue, the stipulation designating exclusive venues should be strictly confined to the specific undertaking or agreement. The basic principles of freedom to contract might work to the great disadvantage of a weak party who ought to be allowed free access to courts of justice. Restrictive stipulations are in derogation of the general policy of making it more convenient for the parties to file actions arising from or in relation to their agreements. The restriction should be strictly construed as relating solely to the agreement for which the exclusive venue stipulation is embodied. Okay, San Miguel Corporation versus Monasterio. So in this case, San Miguel entered into an exclusive warehouse agreement with Monasterio. Monasterio, who is a resident of Naga City, filed a complaint for collection of sum of money against San Miguel before the RTC of Naga. Monasterio claimed for unpaid cashiering fees because aside from rendering service as a warehouseman, he was given the additional task of cashiering, for which he was promised a separate fee. Now, San Miguel moved to dismiss on the ground of improper venue because their exclusive warehouse agreement provided an exclusive venue stipulation in the courts of Makati or Pasig. Okay. However, in this case, Supreme Court said the cause of action in the complaint before the RTC of Naga was not based on the exclusive warehouse agreement, but concerned services not enumerated in the agreement. Restrictive stipulations are in derogation of the general policy of making it more convenient for the parties to file actions. Thus, the restriction should be strictly construed as relating solely to the agreement for which the exclusive venue stipulation is embodied. Expanding the scope, such limitation will create unwarranted restrictions which the parties might find unintended, arbitrary, or oppressive. Venue stipulation should be deemed merely permissive, and that interpretation should be adopted which most serves the parties' convenience. Since this case for collection is a personal action, we find no compelling reason why it could not be filed in the RTC of Naga, the place where the plaintiff resides. So the exclusive venue stipulation should cover only cases filed or arising out of the contract. If it is something which is out of the contract or not encompassed by the contract, the general rules on venue will apply and will not be subjected to the exclusive stipulation on venue. Lay construction versus Sedanyo. In this case, lay construction filed a case for collection of sum of money against Sedanyo before RTC of Valenzuela for failure to pay the rent. Now, the Sedanyo pointed out that venue was improperly laid since the lease contract provides that all actions in connection with the case shall be filed with the RTC of Pasay. The Supreme Court held that the court is convinced that all these elements are present and that the question stipulation is a valid venue stipulation that limits the venue of the cases to the courts of Pasay City. This is evident from the use of the phrase exclusive of all others. Notably, the fact that this stipulation generalizes that all actions should be filed with the RTC of Pasay to the exclusion of all the other courts does not mean that the same is a stipulation which attempts to curtail the jurisdiction of all the other courts. The said stipulation should not be construed should be construed as one which merely limits venue. Since the lease contract already provided that all actions involving the breach should be filed with the RTC of Pasay and that petitioner's complaint fell within the RTC's exclusive original jurisdiction, the latter should have been followed. It is undeniable that petitioner filed its complaint with Valenzuela RTC, hence the same is clearly dismissible on the ground of improper venue. Ochoa versus China Bank. This case involves petitioner's mortgage real property located in Parañaque. By express provision of Section 2, the sale can only be made in Parañaque, meaning the extrajudicial foreclosure. The exclusive venue of Makati City, as stipulated by the parties, cannot be made to apply to petitions for extrajudicial foreclosure. With respect to the venue of foreclosure sales, extrajudicial, Act 3135 applies, it being a special law dealing particularly with extrajudicial foreclosure of real estate mortgages and not the general provisions of the rules of court on venue. So the stipulated exclusive venue of Makati City is relevant only to actions arising from or related to the mortgage, such as the petitioner's complaint for annulment of foreclosure, sale, and damages. Okay, so that is all for venue of actions. Thank you for listening and don't forget to subscribe.